We're going to try this again. Andell Brown, are you there with us? Andell, so glad that you're here with me because we've had this interesting case. And, you know, normally with DUI cases, they're not all that interesting and they're not all that hard to try because you've got a blood alcohol level, and here we've got a blood alcohol level of 0.14. You've got the defense actually admitting that he was driving the car, that King was driving the car, and that he was inebriated. But here, the prosecution has charged him with something that's a little unusual, haven't they?
Something we see very often in drunk driving cases. Most of the time, you're going to see some type of vehicular manslaughter, driving under the influence type charge. But in California, this is something that has been done before, and the prosecution has done in this case.
And in doing so, they bring into play the state of mind of King, which is where the defense seems to be going, as per his opening, where they seem to be defending the case. I think that he's going to straight out say, you know, listen, he was driving, he was drunk, all of that is for sure, but he did not have the wherewithal to create the state of mind that's necessary for this murder charge. What do you think of that defense?
Well, I think the defense is on point. In California, in order for a murder charge to stand, the prosecution has to prove not only that someone died and that you did it, but that it was done with malice aforethought. That's the words used in the statute, meaning that you consciously knew what you were doing and you decided to do it anyway. That's what the prosecution has to prove here. I think the defense has taken the position that, look, we understand this is a bad case and people lost their lives and something bad happened, but this is not murder. Murder is reserved for truly bad guys. And even though he did something wrong, he's 21 years old, he's a Marine, he made a terrible mistake. People died, but this is not a murder case.
Yeah, and I think that, I agree with you 100% as usual, Andell, but I also think that what the defense has done here is very smart, because you pointed out the fact that, you know, it's a tragic case. You've got two beautiful young medical students, one of whom was the designated driver, who specifically went without drinking at all of these parties in order to be safe. And you've got these victims who are quite injured, especially the last victim that we heard from. I mean, he's got a brain injury. He had to keep leaving school and going back, serious injuries. And I think it's a really good call on the part of the defense not to cross-examine any of the victims. What do you think?
Well, I think that's very smart, and it's a technique that I've used in my trials many times. The victims, they're sympathetic figures, or the people that have survived, they've lost friends, they've been hurt. There's no point in grilling them in a cross-examination. We understand that they were hurt. We understand that these things happen. As a defense attorney, your job is to stick to your theory of defense and really focus on those facts and the law that helps your client. Whether or not what this person said is true, we have no reason to not believe them, but there's no point in getting into a nasty back and forth with someone in that position.
Yeah, I agree with you, but I think that sometimes, I mean, you note that you've done this in some of your cases. I think that that's something that comes with experience and sometimes maybe a little bit of age, that you're willing to let people go unquestioned. I know as a younger attorney, it was really hard for me not to cross-examine every witness. I felt like that was my job. And sometimes it's your job as an attorney to just sit back and shut up. And did you ever find that to be a challenging thing, or that sometimes lawyers just can't overcome that need to say something?
Well, come on, Heather. We're lawyers. We like to talk. We always have something to say, right?
That's it. That's a problem.
So I think experience teaches us that you got to make sure the main thing is the main thing.
Yeah.
And a lot of times in trying a case, less is more. You want the jury to be focused on the most important part of your case. All the other stuff is just what we call dicta, right? The stuff in the case that doesn't have anything to do with the holding. If you can get the jury to focus on that important part, I think the juries appreciate lawyers that get to the point, lawyers that don't waste their time, lawyers that make sure they have the facts they need, the law they need, and send them on their way. And I think that's what the defense is doing here.
You couldn't be more right. I mean, one of the things the defense attorney specifically said in his opening, and I thought that this was brilliant, he said, I don't want to waste your time. I'm not
Right.
going to waste your time with cross-examination that doesn't go to the point of my case. You know, I always say that trials are two dueling stories. And these stories really are dueling stories, because here you have the prosecutor telling this sympathetic, tragic, terrible story of dead medical students, injured medical students, opportunities lost, lives forever changed. And you've got the defense telling a story that there was no willfulness. There was no mental status to set up a murder charge, and not getting into the tragedy, not contesting the tragedy. So it's really, instead of dueling stories, it's sort of parallel stories. How do you think the defense will do, and what do you think is the defense's ultimate goal in this case? Because it's certainly not a not guilty.
Right. I think the defense's ultimate goal is to mitigate the damage to their client. If you look at what's going on there, with the murder charges, you're looking at a floor of 15 years. It begins at 15 years up to life. If you look at the vehicular manslaughter with gross negligence, you have 4, 6, or 10 years as the maximum sentence. So I think what the defense team is doing is they're trying to make sure that their client, Mr. King, fits in under the statute with the lower sentence. I think that's their strategy, and I think they're doing a good job of it. They're also trying to contrast themselves with the prosecution and saying, hey, we're not here to waste your time. Without actually saying it, they're telling the jury, I think they're wasting your time because they're overcharging this case, and they're talking about, of course it's sympathetic, of course it's terrible, but let's deal with things as it is, not as we want it to be. I think what they're trying to show is that the prosecution is somewhat grandstanding because of the high-profile nature of this case.
Yeah, I think you're right. And I think that because of that, the prosecution is also moving very quickly. In fact, some of our chatters noted that the prosecution is moving very quickly through this case. The case is moving quickly despite the fact that the judge takes very long breaks. She's given us a 2-hour lunch break, which means that you and I, and then you and Misty, get the opportunity to really dive into some of the issues here. Before we go on, though, I want to, since these openings were relatively short, I want to play them to give some context to the discussion here. I think the prosecutor's opening is about 15 minutes or less. We'll play it and then discuss it either. I'm sorry, is it ready, guys? Okay, it's not quite ready. We're still working on it, but as soon as it's ready, I'm going to play it. And then it may be, Andell, that you end up discussing that with Misty because she's taking over from me in just a minute. But we are going to play the prosecution's opening because I want to focus on the fact that she is very focused in on his mental state, because she has to be. And then you'll see and be able to contrast that with the defense, who's also focused on the mental state and saying that it just wasn't there. So here's the prosecutor's opening. Andell will be right back with you. Depending on the timing, it'll either be me or Misty.
He was warned of the consequences of driving impaired, but he chose to do it anyways, taking the life of Andell Baldock and Madison Cornwell. On May the 15th, 2015, Andell Baldock, Madison Cornwell, and 3 other friends from UCSD Medical School, Stosh Ozog, Jared Molatoris, and Yuki Izuka, all attended a house party in Hillcrest. They attended this party to celebrate the end of their 2nd year of medical school. Madison Cornwell was the designated driver. She didn't have a drop to drink at that party. When they left the party at around 1 in the morning, they dropped one of their friends off at his home in Hillcrest before they made their way onto the freeway, State Route 163. What none of the occupants of that car knew was that about 8 miles away, the defendant had also been drinking that evening. The defendant had also been partying. He started his night off with some Marine Corps buddies. They were partying at a hotel in Mission Beach with his friend Dylan Wolfrey's parents who'd come into town from Maryland. And when they met up at that hotel, the defendant later admitted that he had several beers with his friend Dylan. They had some pizza, and he spent several hours there. At around 11 o'clock, though, he decided he wanted to leave. And his friend Dylan Wolfrey told him he didn't have to leave, that they had a bed for him, and that he shouldn't drink and drive. He left anyways. And he texted his friend Hannah Talbot. He texted his friend Hannah Talbot to meet him at another bar. When he met her at the first bar, it was called Carriage House. She she wasn't comfortable with the bar and she thought it was kind of sleazy, so she didn't get out of her vehicle. They then decided to go to a different club called In Cahoots. When they got to In Cahoots, the defendant was driving his own truck, a lifted Ford F-350 that he just owned for a little over a week. He parked in the parking lot of the nightclub, a country western bar. And when he parked in that club, he then decided to walk in with Hannah Talbot. He actually got sent away from the door because he had a knife with him. He had to put that into his vehicle. He came back to the door, and as he and Hannah walked in, it was about 11:30 in the morning, or in the evening. He and Hannah walked into the bar, and they immediately stopped after they paid the cover to get a shot from the shot girl that sat right inside the door. They each had a shot of Jack Daniels alcohol. They went to the bar and he purchased a drink called an AMF, Adios Mother Effer. And in that drink there's at least 2 ounces of alcohol, a combination of vodka, gin, and rum. They each purchased the drinks, went upstairs to play some pool. While they were playing pool, he continued to drink. And what Hannah Talbot later told one of the investigators in the case, that when she first met up with the defendant, he reeked of alcohol. But she didn't notice any impairment until they started playing pool. Because Hannah Talbot knew this defendant. They worked together. They'd been friends for a year and a half. And she knew, and she'd been out with him when he's been drinking before. And she knew what it was like when he had too much to drink. And as they were playing pool, they continued to order drinks. But the defendant continued to get sloppier with that pool cue, and he was having difficulty with his balance. After about an hour and a half, Hannah Talbot decided that it was time for them to leave. The defendant was having a really difficult time playing pool. They'd had several drinks. They'd had double shots of Jack Daniels and Coke. They'd come back downstairs at one point in time. When they returned upstairs to play another game of pool, that's when Hannah Talbot decided it was time for them to leave. She went into the restroom, and when she came out, the defendant wasn't there. As she looked around, she realized that she got a voicemail on her phone, and she looked at the voicemail, and it was the defendant calling her saying that he'd been kicked out of the bar. The bar manager, Gary Martin of In Cahoots, couldn't tell you that he noticed the defendant when one of his staff came up to him and stated that he wasn't sure if the guy was impaired or injured, but he was slumped over at the railing at the bar. And so Mr. Martin went and checked out the defendant and had him escorted out of the club, had him go to the patio, the front area of the club, which is where they have people go when they're trying to assess whether or not they're impaired, whether they're too intoxicated, whether there's something else going on. And so the defendant was escorted out of In Cahoots onto this patio. And as he's on this patio, at one point in time, Mr. Martin saw him make a telephone call. Mr. Martin thought he was calling someone to pick him up. That was the phone call that he made to Hannah Talbot. After he'd been outside for about 15 minutes, Mr. Martin wasn't paying as much attention to the defendant any longer. At one point in time, he saw the defendant standing in the bed of a big white truck. He was walking an employee out to his car, so he didn't pay much mind to it. About 5 or 10 minutes later, he saw the defendant again by the truck standing there. Hannah Talbot had come out of the bar. She got into an argument with the defendant. She told him not to drink and drive. She told him he was in no shape to drive. She fought with him to get the keys. And then he did something that made her very uncomfortable, and she walked away. And she yelled at him to come to her house and he better get there alive. When the defendant had been outside about 25-30 minutes, Mr. Martin heard the sound of a loud truck starting up. And when he looked out into the parking lot, he could see that the defendant was behind the wheel of his vehicle. And Mr. Martin went out to that vehicle and told him that he would get him an Uber or a Lyft, or he'd get him a cab, that he was in no shape to drive. The defendant said, "I'm good," and sped off. 8 days before this crash occurred, the defendant, as well as his Marine buddies, Dylan Wolfrey, Hannah Talbot, his boss, Jennifer Mata, they'd all attended a safety stand down, which in the Marine Corps, that safety stand down was geared towards the 100 days of summer. that was geared towards telling him about the dangers of drinking and driving. And even though the defendant was late getting to that safety stand down, he was there when the police officer got on stage at the Bob Hope Theater on Miramar Air Base. And that police officer got on stage and told this group of 300 to 500 Marines the dangers of drinking and driving. The defendant was there during that discussion. His boss, Jennifer Mata, remembers seeing him. The defendant left In Cahoot's bar, and as Madison Cornwell is making this turn on the 163, just past the 8, she's driving north. Jared Molitoris, who was sitting in the front right-hand seat of her vehicle, he remembers seeing these really large headlights, and he didn't really comprehend what they were or why they were so close. And before they even had a chance to scream or react, he braced his hand on the front of the vehicle, on the dashboard, for the impact. The impact of this vehicle took out the entire left-hand side of Madison Cornwell's Prius. Madison Cornwell and Andell Baldock were killed instantly. Their bodies practically fused together. The defendant continued on the freeway as his truck flipped and overturned. The debris field was over 100 feet long. Madison Cornwell's Prius, the entire left-hand side of the car was ripped off. Madison Cornwell and Andell Baldock were killed instantly, but there were 3 other people in that car. Sitting in the front seat was Jared Molitoris. And Jared fractured his sternum and bruised his heart. Stosh Ozog was sitting behind Jared in the vehicle. And Stosh Ozog suffered fractures to his spine. And in the middle of the rear seat was Yuki Izuka. And he suffered several fractures as well as a traumatic brain injury as a result of this crash. The defendant's vehicle, as it overturned, he was extracted from the vehicle when the fire and police showed up, and he smelled of alcohol. When he was taken to the UCSC Medical Center and treated, his blood was taken an hour and a half after the crash, and the result came back to a 0.14 blood alcohol level. You'll hear from a lab analyst who will say at the time of driving his blood alcohol level was about 1.6 or 1.7, more than twice the legal limit.
Good afternoon, everyone. I'm Misty Maris. Welcome to the Law and Crime Network. We're here in California watching clips from the Jason King case. We just finished watching the prosecution's opening. Now, for those of you who are just tuning in, the King case, this is a vehicular homicide case, but it's got a little bit of a twist. King is actually being accused of murder, and he's on trial for murder, which is unusual when you're talking about a case involving vehicular homicide. The allegations are that he was operating a vehicle while intoxicated, resulting in the death of 2 California medical students when he drove the wrong way down the road and ended up in a head-on collision. This is an interesting case, though, and a lot of pretrial issues focused on the fact that I don't know if murder is the correct charge here, and that's what the defense tried to argue. However, the judge is letting the jury decide, so the case is going to trial with those murder charges on the table. To break this down and to get through some of these nitty-gritty legal issues, we have Andell Brown. He is a trial attorney. Andell, thank you so much for joining us this afternoon.
It's a pleasure to be here.
Oh, absolutely. And I know you were with my friend and colleague, Heather Hansen, before, so I'm sure you guys really broke down some of this case. And we just listened to the prosecution's opening. What I think is so interesting about this case is that you have somebody who, I mean, look, there's really nothing to contest that this guy was intoxicated, but the murder charges. It seems that the prosecution is focused on the fact that here you have a Marine who had gone through some training about the safety or the implications of driving drunk, who had gone through a seminar. I think it was just a couple weeks prior to this accident. There was a seminar which talked about the consequences of operating vehicles while intoxicated. That seems to be a sticking point in this case for the prosecution. And what's really feeding into this argument, what's this guy's state of mind? What do you make of all that, Andell?
Well, I think you hit the nail on the head. I think the issue is the state of mind, and that's the difference between the murder charge and the vehicular manslaughter charge. Here, the prosecution is saying that it's not just an accident where somebody died, but he knew he was doing something dangerous, and he did not care. He went forward consciously knowing that he could kill someone, and he did that, and he should face murder charge. That's where the prosecution is coming from on this one.
And that's going to be submitted. I mean, right now we saw that in some of the pretrial motions, pretrial conferences, the defense, and it makes sense, and we're all trial attorneys, talking here right now about this, that they wanted to get those charges off the table and just talk about the charges, and I'm going to say the traditional charges that go along with vehicular homicide cases, which is, as you said, vehicular manslaughter, a little less focus on state of mind. Now, what you were talking about before with respect to the murder charges, what does the prosecution have to prove? Is it reckless? Is it something more? What's the standard?
The actual standard is malice aforethought. That's in California. You need that to support a murder charge. You have to prove that it's beyond gross negligence, not that you committed an act with indifference to the consequences. That's gross negligence, but that you committed an act knowing the consequences, knowing that it was dangerous, knowing that it could cause death, and you proceeded anyway. And that's the line that the line of demarcation between the two charges that the prosecution wants to cross. And I think here they're trying to say that you're a Marine, you've taken courses on this. Not more than 8 days before this happened, he had taken a training course that talked about how dangerous it is to drink and drive. He had several people that said, you should not do this, you should not get behind the wheel of a car. He ignored all of those things. And the prosecution saying, you can't do that and then just say this was a mistake. That was intentional, and that's murder.
Yeah, certainly a compelling argument. And from what we saw today, some of the other people that survived this crash, we saw some testimony, very compelling testimony. We know some of the facts that you brought up, Andell, which are very pertinent to the case. We know that he did his blood alcohol level was above the legal limit. We know that there are several witnesses who are testifying that he was told, you shouldn't drive. Somebody said you should stay at a hotel, you should stay over here, you don't have the ability to go behind the wheel. But to me, from a legal perspective, and when you're talking about this based on the language of the statute, which you so eloquently articulated for all of us, is there a more far-reaching consequence, though, if you say that anytime there's a vehicular homicide case, if a person took, and he's a Marine, I know that there might be more intricate training, but hypothetically, if an average Joe had taken some sort of defensive driving class that dealt with alcohol consumption, let's take it a step further. How about when you have kids who are just on the brink of getting their license to 16, 17 years old, and they're taking driver's education, or people that are getting their license later in life taking driver's education classes that might cover that subject matter? Is this almost an automatic jump, where now if you've participated in some sort of informational or educational session on that topic, that the charges could be amplified?
Well, the case that all of this turns on is the Watson case that came out, I think, in 1981 out of California, where the idea was introduced that it's okay to charge a murder charge for when there's a drunk driving case. In that case, the facts were a little more extreme. The driver in that case, the blood alcohol content was almost twice the legal limit. That person had narrowly avoided an accident before they got into the ultimate accident that killed a person, and also they were traveling at a ridiculously high rate of speed. Here, he was given admonitions not to drive, and he had taken courses, but I'm not sure it rises to the level that we saw in the original Watson case. And that's where the prosecution is going to have a little difficulty. And to your point, Misty, when it comes to whether or not we're going to charge everyone with this charge, if you flipped it on the other side, I'm sure the prosecution would say not everyone deserves this charge, but they would say he does because he knew better and he had other options, and he willfully decided to drive drunk, and his actions killed people.
Right. Yeah. Andell, and you bring up a great point, because that's the whole crux of this case from the prosecution's perspective, and the defense will contest it, is what's that state of mind? And I think a lot of the testimony that's going to be weighing heavily on the jury are those statements made by other people where he is told, you should not be driving, you don't belong behind the wheel, you're not capable of driving right now. And I think there's a statement out there that we've seen in the press leading up to the trial where he says, well, I got myself here, I'm capable of getting myself home. I mean, that shows a little bit of wherewithal. You're making that choice, despite the fact that people are pleading with you to not get behind the wheel, to go behind the wheel. So is that really going to be a lot of what the prosecution focuses on as we watch this trial unfold?
Absolutely. They're going to focus on the fact that this was willful. He made a conscious decision. He chose to drive drunk. He knew it was dangerous, and he did it anyway.
Now, say the jury says, okay, well, we pretty much, there's not a lot of argument. We see these cases where maybe there wasn't a blood alcohol test, maybe there weren't witnesses around. So oftentimes a drunk driving case in any sense is difficult to prove if you don't have some sort of testimony, witness testimony, or objective evidence that somebody was intoxicated. But that's not an issue here. So what happens if the jury says, hey, we don't really buy the murder charges. We think that that's a little bit too much, that's too far, but we have two people who are dead because of this accident, and we also have ample evidence of intoxication. What happens in that scenario?
Well, Misty, I think that's a great point, because looking at the facts of this case, you have the perfect situation for what we like to call, as you know, splitting the baby, where the juror look at what happened. They say, you know, we think he's guilty, but we're not going to charge him with the highest crime he's charged of. We'll find a lesser included and give him that. In this case, he has the murder charges where he's looking at between 15 years to life on each of those counts. But on the vehicular manslaughter with gross negligence, he's looking at 4 to 6 to 10 years. Now, the jurors are not supposed to know the punishments, but I think they'll get the general idea that those are lesser charges. He's 21 years old when this happened. He's a young man. He's a Marine. He's a soldier. A lot of us, we have a great amount of respect and deference for those that serve. So I wouldn't be surprised if the jurors looked at this and said, you know what? He has to be responsible. He has to own up to what he did, but we don't think he's a murderer, and they quote unquote split the baby.
Yeah, I think that certainly could be where this case goes. We'll have to see it as the story unfolds. We did see some witness testimony today, which was very compelling, would definitely tug at the jurors' heartstrings. What do you think? Do you think the jury is sitting there thinking, look, these two young ladies lost their lives, and here we have other witnesses who survived this accident? And boy, this is something that's really an emotional moment right out the gate in this trial.
Yeah, I think the prosecution, they're harping on that. They're focusing on that. They're focusing on the devastating effect of his actions, of the effect that it had on, obviously, the people who lost their lives and the student that survived, because they have to live with that memory for the rest of their life. I think that's what they're focusing on. And the defense's job will be to take the focus off of the devastating effects and say, look, we're here to charge him for what he actually did, because that's what the law asks us to do, and you all promised to follow the law. And what he actually did was wrong. It affected these people. We don't deny that, but what he did was not murder. That's what they're going to argue. He didn't have the mind state for that, and it's not the appropriate charge. it's an overcharging by the prosecution. That's where they're going.
And that's what the defense tried to argue before the trial, correct? This is overcharged. He shouldn't be facing these murder charges. It should be limited to the manslaughter, vehicular manslaughter, or those types of charges. Do we know if a plea deal was offered? Do we know if there was any sort of discussion of a plea bargain? It seems like this would be a case, especially when you have objective evidence of intoxication, that would be ripe for plea discussions.
I think there were two, from what I saw, there were at least two plea agreements that the defendant refused. He denied. He said, I'm not going to accept. I believe one required at least 25 years in custody in prison, and then the other one going up to life. The other one required about 15 years or more. Obviously, it looks like in California, in this jurisdiction, what they're doing is you have to accept a plea, and then the judge decides the range of the sentencing. And it looks like he turned down two previous plea offers and decided to go to trial.
Yeah, it sounds like there was a lot of hefty time that was being attached to those plea offers. So perhaps from the defense attorney perspective and the client, you say, all right, let's roll the dice and see what happens. And we don't know exactly where the defense is going to go as the case unfolds, but we can get a pretty good idea from the roadmap that the defense lays out in their opening statement, which, Andell, I want you to stick around if you can, because I want to talk a little bit about what we can anticipate from the defense side. We talked a lot about what the prosecution is basing their case on, but what's the defense going to do? So let's review the defense opening statement right now, and then we'll circle back with Andell and break this down further.
Good morning, ladies and gentlemen. Please remember that at this stage of the case, the opening statements are designed to help you follow the evidence and follow the real issues of the case. I've been practicing criminal law for a long time. Started as a DA, self-defense lawyer for a long time, as Mr. Casey. And I will tell you, this is probably one of the more unusual opening statements I'll ever make. Because we agree with most of the people's case. We agree that our client, Jason King, was the sole cause of this accident. That he was the sole cause of the death and the injuries. We agree that Madison Cornwall was driving 100% appropriately, 100% sober. Those are stipulated facts in our mind, but you'll hear evidence about it. So there'll be a number of witnesses, this is unusual also, where we're not going to even cross-examine. For instance, the coroner's going to come in and testify to a cause of death, multiple blunt force trauma. We have no issue with that. We have no issue with the medical testimony concerning the 3 young people that did survive. So what are the issues in this case? Our client is guilty of manslaughter. He's guilty of driving under the influence with injury. He's guilty of the enhancements of causing great bodily injury. So where are the issues? What is the issue here? And this is what we want you to keep your eye on. The issue here is the prosecution wants you to convict Mr. King of 2 counts of murder. That is where the issue is in this case. Period. Murder, there will be a lot of jury instructions on it. But the key issue in murder is an implied malice murder, and it requires the jury to believe that a defendant acted deliberately with a conscious disregard for life. Acted deliberately with a conscious disregard for life. Now, how do you prove that? When we picked this jury, I think everybody agreed that drinking and driving is dangerous. Everybody agreed that drinking and driving is unlawful and can result in death. And yet, if you got involved in a fatal accident under the influence, you'd be charged with some form of manslaughter, either negligent manslaughter, intoxication involving death.
Objection, Your Honor.
Overruled. or gross vehicular manslaughter, intoxication involving death. So what makes it murder? What makes it murder is that a given defendant in a given case has acquired specialized knowledge about the real dangers of drinking and driving. Now, let me jump ahead and then I'll come back. The defense is going to call a witness, Arnold Abrams. This is the witness that we typically call by the prosecution in this type of case. Mr. Abrams runs 3 first offense driving under the influence schools. What happens in California, as in probably every state around the country to some degree, is that if you're convicted of a DUI, you are required to go to an alcohol school. The first offense in this state all the alcohol schools in this state are run through Title IX of the California Code of Regulations, and specifically California Health Services. They set minimum standards for these programs statewide. They approve the instructors, the people that operate the school. And on a first offense, minimum, it's a 12-week program where you're taught the real dangers of drinking and driving, where they emphasize what would happen to you because you're getting the specialized knowledge about how dangerous it is to drink and drive, that if you should happen to get in a DUI accident, killing someone, that it's not gross vehicular manslaughter anymore, it's murder. That's what people learn. In addition, you'll learn that in the courts of this state, for about the last 10 years or so, whenever someone pleads to a DUI case, a simple DUI case on, you get an advisement. And the advisement says, I acknowledge that I've been convicted of a DUI, this is dangerous conduct. If I continue to drink and drive, and if I should kill someone, I can be charged with murder. So defendants are put on notice of that. In addition to that, defendants most of the time are required to go to a Mothers Against Drunk Driving program called MAD, or Victim Impact Panel, where there's a speaker, a series of speakers. One of them usually is a person who is a family member of someone who's been killed or injured by a drunk driver. That's the specialized knowledge that really is required to make it murder. Now, what's the evidence in this case? The Marines stand down, 1 or 2, 300 to 500 people, there's an explanation of drinking and driving. That's it before that night. And the idea behind this is that you learn the dangers of drinking and driving and the high probability you could kill someone. And so when you're sober, before you start to drink, before you become impaired, you know better. You really know better. And that's how it becomes acting deliberately with a conscious disregard for death. The evidence will establish that once you start drinking alcohol, the alcohol impacts you so you can no longer make conscious, rational, good decisions that you made when you're sober. In other words, you think you're fine to drive when you're not, among other things. Our client was in the Marine Corps at the time. We don't expect any benefit or sympathy for that. But we don't expect him to be penalized for that either. The only evidence they have is a Marine stand down before the night this happened. He's from Dion, Oklahoma, a small town in Oklahoma. Doesn't even have a traffic light. About 1,000 people, close to Telewalk, if you're familiar with Oklahoma at all. And he's been a Marine here locally for about less than a year before this incident happened. So where this case should center on is his pre-existing knowledge, what he knew before he started drinking that night. And that's why this simply is not a murder case. It is a manslaughter case with causing injury, death. It's a DUI with injury, and he should be convicted of those charges. So, when we start the evidence, Mr. Casey and I are probably going to pass on cross-examining a number of witnesses because they're not the issue in the case. And we're not going to stretch this out unnecessarily. we can make this a lot quicker if we just focus on what the real issue in the case is, and that is murder. Thank you for listening.
We just watched the defense opening from the Jason King case in California while we wait for court to be back in session. The court took a 2-hour break, so we will keep you up to date when the courtroom is back. But as of now, we're going to review some of these clips. We watched the prosecution opening. We have now watched the defense opening. There were a couple witnesses who've already testified, and we anticipate more witnesses this afternoon as this case goes on. We talked for a while with Andell Brown. He's a trial attorney, and we broke down what the prosecution is looking to prove in this case. We watched the prosecution's opening statement where there was a lot of focus on the emotion, on the horrific effects on the 2 lost lives, as well as the effect on a survivor of the crash. And there was a lot of focus on those aspects of the case. Also, prosecutors sharply focusing on the fact that the defendant in this case had taken a class where the risks of drunk driving were addressed while he was in the Marines. So there's a training class that he took that specifically addressed that issue. Another focus for the prosecution, the fact that he was told by multiple witnesses who are going to testify that he was told, do not get into the car, you're not capable of driving, and despite those pleas, he got behind the wheel, ultimately resulting in the death of 2 people. Now we just watched the defense opening, and as you can imagine, the defense telling a little bit of a different story and shifting some of the focus off that pre-existing knowledge that the prosecution was so fervently talking about during their opening. Andell, let's talk a little bit about what the defense has set forth so we can see where they're going here. The defense attorney said, and I have it written down because I don't want to get it wrong, that yes, that when you are sober, you are making those rational decisions and that you know better. But when you're intoxicated, you don't know better. So this case really comes down to pre-existing knowledge. Now, Andell, is that going to be enough with these murder charges on the table to say that before he got behind the wheel, he knew that drunk driving was wrong? I mean, I think you could say that for pretty much anybody who is driving a car. We all know that. And the fact is that some people, despite knowing that that's not a good idea and that it's dangerous, still gets behind the wheel. So what makes this case different?
I think what his defense lawyer is getting at is a diminished capacity defense. He's saying that the crime of murder requires a specific intent that you have to develop in the mind, the mens rea, in order to commit this crime. His defense attorney appears to be getting at saying, look, because he was so intoxicated, he could not have developed this specific intent. Under normal circumstances, he'll remember the classes he took. Under normal circumstances, he'll hear the things that people are saying and think twice about it. But under these circumstances, because of him being intoxicated, he wasn't operating in a normal way. And because of that, he couldn't have committed murder. He didn't have the specific intent.
Yeah, definitely. And that's a very clever argument. And Andell, what I want you to explain to our viewers, because this was always something that I think is very perplexing when you break down these trials, because you can use evidence of intoxication to speak to specific intent, to speak to the defendant's intent. However, it's not a full defense because voluntary intoxication is not a defense. So oftentimes, and we get a lot of questions about that because it is it's almost a law school issue, right? It's kind of something you see on the bar exam to understand how those two theories operate together. Can you explain that to us and in the context of where the defense is going with this?
Sure, Misty, no problem. I think what the defense is saying, and as you rightfully noted, that it's not a defense to the crime. You can't say that, because I was intoxicated, I didn't drive drunk. Obviously, that doesn't work. However, specific intent crimes like murder and some other crimes, they require you to form a specific state of mind. And if you were intoxicated, that intoxication can warp your ability to think about things clearly. And if you're not thinking clearly, how can the prosecution prove that you had that particular state of mind? And that's the division. while it's not a defense to a crime, let's say if you were to get intoxicated or you take drugs in your system and you commit a crime against each other, you can't say, well, I didn't intentionally beat that person up. It's because I was drunk. That's not going to work. However, here where you have a specific state of mind where the prosecution has to prove that you willfully did this act, you willfully formed the correct state of mind to commit the crime, intoxication can show that you couldn't have done that in that state.
Yeah, that's probably going to be some of the focus here. And you did a great job of breaking that down, because that can be very confusing. And it seems like from the perspective of the defense, that really is what you're going to have to argue. And it's an interesting dichotomy, because on one hand, you're talking about essentially admitting to being intoxicated. Now, we know that in this particular case, there's not really a great defense on that point, because you have the blood alcohol levels and you have the witness testimony, but the objective evidence is tough to overcome. So that's probably the best defense strategy, and that's where we're going to see this go. Now, another issue that came up during the defense opening is the intent to call this witness. And this is a witness that would typically be called by the prosecution in most of these cases. But this is somebody who runs a DUI school, and they're going to talk about those training courses and what that means. Now, what do you think of that? How is the defense going to use that type of expert testimony to play into their defense? We can only opine right now, but I'm interested in your take.
Well, you know what I think, Misty? I think the defense is trying to get across the point to the jurors that this could happen to almost anyone. Anyone that goes and takes one of these 12-hour courses, whether it's through traffic school or something like that, they've taken a course and they're hearing about how dangerous it is to drive drunk. In many other ways, everyone knows it's dangerous to drive drunk. So I think what the defense is kind of getting at with the jurors is tapping into their sense of fairness and saying, look, it's fair to hold them responsible for driving drunk. It's not fair to hold them responsible for murder. The reality of it is almost anyone that's driving drunk has heard that it's dangerous to do so. And in the legislation creating this statute, the intent of the statute was to create separate categories for people that drive drunk, commit manslaughter, and people who do things like murder. We think of murderer and we think of murder as one of the highest crimes. We think of a murderer as the most degenerate type of person. This young man, because he's 21 years old, this Marine is someone who made a mistake, is someone who committed a crime. He's not a murderer. I think that's what the defense attorneys are getting at. They're trying to make sure that their client appears sympathetic like an everyman, and that they can get to the point that they think the prosecution has gotten carried away.
I think you're right, Andell, because another piece of that is they talk about that in California, as in many states, that if you have any sort of even minor driving infraction regarding that has anything to do with intoxication, you have to go through these types of courses. They set the bare minimum and standards of how to operate on the road, these defensive driving type classes. And I think your point is well taken. This is an everyman. You might even have people on the jury who have taken a class like that, and maybe they're going to say, these aren't specific to, these aren't specific classes that are some sort of expertise outside of what the average person might know. So how can you hold them to this higher standard of murder? And I think you're right. That's where it's going to go. So what about the fact that he's a Marine? Do you think, and whether I'm talking rightly or wrongly, this is not necessarily something that's going to be written into the law, but when you have the jurors in the box and you have somebody who is a Marine, who's in the military, an intelligent person who's gone through this class in the context of his military training, is that going to make a difference in the jurors' minds? I think that you're going to see the prosecution focusing on that fact.
Well, Misty, that's why jury selection is so important in every single case, and it's of the utmost importance in this case. What the attorneys for the prosecution and the defense especially should have done was to talk to the jurors to find out if the fact that he is a Marine is going to cause them to look at him any differently than anyone else, because you want to find that out in jury selection to make sure that they're just going to look at the facts, they're going to look at the law, they're not going to give him any special treatment because he's a Marine, or they're not going to hold him to any special standard because he's a Marine.
Yes, and that's really what is supposed to happen, whether or not that will. And you're right, that's definitely something for voir dire.
Whether it will.
Yes, whether it will, we don't know, because, of course, and it could cut both ways. Oh, we don't really know who's on the jury. It could be something that's positive for the defendant. It could be something that's negative for the defendant. As you said, somebody could say, and I was picturing this too, because there is so much emphasis on the fact that he's a Marine, and in many cases, that wouldn't necessarily come into play in the trial, and it would be difficult to be talking about that with any length of time during the trial. From the prosecution's perspective, the defense would object, and it would be completely irrelevant to the case. But in this case, the prosecution's kind of found a back door to get that in the sense that there is this driving while intoxicated class that he took through his training. So all of a sudden that now becomes a relevant factor. And I don't think that that's lost on the prosecution, that they're making that point. And we could see, if you have the defense bringing on a DUI expert who teaches this type of class, do you think you're going to see the prosecution in rebuttal bringing an expert on that says, hey, this class was a little bit more than what the average Joe is going through because it's done from the military perspective?
Yeah, I think that's what we expect as civilians. We expect that our military officers are trained, that they have the knowledge, that they have equipment that we don't have. So I think in the average juror's mind, they're going to say that this class should have been more involved than the 12-hour course we take down at the DMV. And the prosecution is absolutely going to try to hammer that home. If they have an expert or if they have someone that's familiar with those classes, they're going to bring them in and they're going to have them tell the jury, look, this is not just your everyday driving course. We're specifically breaking down these dangers because we need our soldiers to be at their optimal capacity when they're operating machinery, because somebody's life could be on the line.
Definitely. And in this context, you don't expect somebody with that type of training and background to be driving on the wrong side of the road. So again, it goes back to his state of mind. Was he acting with deliberate indifference? Do you think that it's enough to have witnesses say, we told him not to get behind the wheel and he did anyway? I'm seeing, and this is just, maybe it's because I'm a defense attorney, maybe it's because I've seen a lot of these cases, I'm seeing the prosecution having a little bit of a hurdle to getting to these higher end charges. I think that even with witness testimony that somebody says, look, you shouldn't be driving, you shouldn't get behind the wheel, that's common in these types of cases. In any case involving drunk driving, you would interview, you go to the bar where the person was, you talk to the bartenders, you talk to other patrons, you say, did this guy look visibly intoxicated? Did anybody try and stop him? But he went anyway. It's not an uncommon fact.
Right. Not only is it not uncommon, it's also a very subjective issue about what was said, the way he perceived it, the way he thought about it, and the actions that he took based on those statements. We don't know for sure just because someone said it, whether he heard it, and we don't know just because someone said it, whether he interpreted it the way that it was said, or that he appreciated the nature of what they were telling him because of his intoxicated state. And I think one of the things you touched on, Misty, is that when it comes to the specific intent and the murder charges, the prosecution, they have a little bit of an uphill battle here. While everyone agrees that he should be held responsible, I think it's going to be difficult for them to show the specific intent that he had that mindset that was necessary for the murder charges they're looking for.
Definitely. I think that is going to be the biggest problem for the prosecution. As you said, it really comes down to the mindset. So speaking of the mindset, what do you think about this defendant? Do you think he's going to be on the stand? We know that it's uncommon for defendants to testify on their own behalf, but here from a strategic perspective, if you're the defense attorney, you're sitting in their shoes, he might be the best witness to testify as to what was going through his mind at the time. How else do you prove that?
Well,
or refute the evidence that the prosecution's providing. Obviously, as we know, defendants don't have to testify. It's their choice. They don't have to put on any case at all. They can sit there at the table and just say the prosecution didn't fulfill their burden. But oftentimes, of course, defense attorneys do recommend putting on some witnesses. We know they're going to have an expert at the very least. Do you think they're going to have him testify?
Well, as you know, Misty, you kind of make that call as the trial unfolds, and you see how the state's witnesses are doing and whether or not you think they've laid out their case. Another thing that the defense will be doing is looking at how the expert testimony comes out. Does the expert testimony refute the prosecution's stance that he had the right sort of frame of mind? Totally. If your experts do the job for you, there may not be any benefit of putting your client on the stand. But here, we're talking about state of mind. I think putting the defendant on the stand would be a good idea if the rest of the trial says you should, because who else can better say their state of mind than that person? He is the one person that knows better than anyone else what was going through his mind, or should know better than anyone else what was going through his mind. So I think in the end, if the defense gets to that point, they put him on the stand and they make that argument that, look, you've heard from him. You know what was going through his mind. Everyone else is just guessing.
Right, and that could be an effective strategy. And I agree with you, Andell. When you're in the defense chair, you watch the way the trial unfolds and you make that determination, hey, is this necessary based on what happens during the prosecution's case? But I definitely agree with you that in this particular case, that you may actually see the defendant take the stand to speak to that point. As you said, who else is really going to know where his head was at? And you brought up some great points. So when you're talking about that witness testimony about the people who say you shouldn't get into the car, what did he make of that when that was all happening? You know, as you said, did he hear it? Did he understand it? We don't really know. So it's certainly something we could see coming down the pike. Now, as an aside to this criminal trial, one thing I think is very interesting is that in California, there's been a push to have additional legislation regarding what the rights and what the responsibilities of the bartenders are. And there's this push to say, hey, look, we need bartenders who are working in these establishments to understand what to look for to make sure something like this doesn't happen. And in many states, you know, in New York, we have the dram shop laws and potential for civil liability, but that's not a bad idea. Not that a bartender could necessarily control someone's actions outside, but to have them aware of what types of circumstances might lead to a terrible tragedy like this.
Right. I'm sorry, Misty. I had a little law school flashback when you talked about the dram.
I'm sorry I put you in a law school flashback. That to me is the worst. My apologies. Please. I hope you can sleep tonight. Go ahead.
I'm going to try to recover. I'm going to try my best. But here, I think what the legislation, the point of it was to take what was already being done on a local level and make it statewide, these standards of how, you know, bartenders and other people should act, and being able to spot someone that's overly intoxicated, making sure you're not serving someone that's overly intoxicated. Of course, you don't want to shift the responsibility from the person who is deciding whether or not to drink and drive over to a shopkeeper or a bartender or a waiter or someone else like that. You want to make sure the responsibility is where it should be, which is on the person who's making the decision. However, it's not going to hurt to have people with more information, better training on how they can help reduce the possibilities of these types of tragedies.
Definitely, because at the end of the day, that's exactly what this is. It's a tragedy. And from the perspective of the criminal trial, that's why you have people being held criminally responsible for these types of for these acts that result in death, because obviously this is two people just driving down the road who end up losing their lives, and it's absolutely horrific. To that end, you know, you do have in this criminal trial the defense perspective. It really, and I think this plays well to the jury, there's no indication that he's going to argue that he isn't responsible for this. It's just a matter of what that state of mind was at the time and what would be a just result based on the law. So as you said, it seems like the defense is going to be focusing on mitigating, bringing out these factors to get this knocked down to one of those lesser included offenses. So say they have their best case scenario, what kind of time are you looking at if you're able to knock this down to something outside of murder?
Well, the time that the defendant is looking at drastically improves. With the murder charge, it's 15 years to life. With the lesser included charge, the higher charges are either 4, 6, or 10 years. So that means you have a maximum of 10 years on the 2 counts of manslaughter, and then on the other counts they're even less than that. So you go from a position where he's looking at possibly spending the rest of his life behind bars, to a maximum of 10 years if concurrent, and 20 years if consecutive.
Yeah, absolutely. And that's why the defense is focused on that. They're focused on reducing these charges and taking murder off the table. Again, it's interesting, and you talked about the controlling case. It'll be interesting to see how this case unfolds, because it is a bit of a difficult scenario for the prosecution to really prove a murder case on these facts. While we still have you here, Andell, if you can stick around for a little while longer, we're going to play the testimony of Stash Ozog. This is one of the witnesses that we heard from today, and then we're going to factor this in along with what we heard from the prosecutor and defense in their opening statement. So we're going to turn to that witness testimony now.